around the world, governments are grappling with how to regulate algorithmic decision-making. While the EU and Canada have established comprehensive, rights-based frameworks, the US and Australia rely more on sectoral laws, ethical guidelines, and judicial review, resulting in a patchwork of protections and accountability mechanisms. In this episode, we explore how different jurisdictions regulate the use of algorithms in government and legal decision-making. We'll break down the key legislation, transparency requirements, due process safeguards, and accountability mechanisms in the United States, European Union, Canada, and Australia. By comparing these approaches, we'll highlight both the strengths and the gaps in global regulatory strategies and what they mean for fairness, transparency, and human rights in the age of AI. Deep dive, jurisdictional approaches. European Union, GDPR Article 22 and beyond. The EU leads with a rights-based, risk-oriented approach. GDPR Article 22 gives individuals the right not to be subject to decisions based solely on automated processing, including profiling, that have legal or similarly significant effects. This right is bolstered by transparency. Controllers must provide clear, layered information about the logic, significance, and consequences of automated decisions. Human intervention. Individuals can demand meaningful human review, express their viewpoint, and contest decisions. Enforcement. Data protection authorities actively investigate and fine organizations for non-compliance, with thousands of enforcement actions in recent years. However, challenges remain. Defining what counts as solely automated, ensuring human intervention is meaningful, not just a rubber stamp, and harmonizing enforcement across member states. The lack of direct CGU case law on Article 22 leaves some interpretive uncertainty, but the EU's approach sets a global benchmark for algorithmic accountability. Canada, the ADM Directive. Canada's Directive on Automated Decision-Making, ADM Directive, is a pioneering policy for federal government use of algorithms. Key features include algorithmic impact assessment. AIA, every automated system must undergo a risk assessment before deployment, with results published online. Transparency. Departments must publicly report on system effectiveness, fairness, and human rights compliance. Recourse. Individuals affected by automated decisions receive notice, meaningful explanations, and options to challenge outcomes. Oversight. The Treasury Board Secretariat monitors compliance, and the directive is reviewed every 2 years. Recent amendments have expanded the directive's scope and strengthened requirements for bias testing and data governance. While the directive has improved transparency and risk management, some departments face challenges with the complexity of the AIA process and ensuring meaningful engagement. United States, sectoral and state-led patchwork. The U.S. lacks a comprehensive federal framework for algorithmic decision-making. Instead, regulation is fragmented. Sectoral laws. Existing statutes like the Civil Rights Act and Fair Credit Reporting Act address discrimination and transparency in specific domains. Executive orders. Recent federal orders aim to centralize AI policy and preempt conflicting state laws, but do not create new statutory rights. AI Bill of Rights. A non-binding blueprint outlines principles for safe, fair, and transparent AI, but lacks legal force. State laws. States like California and Colorado have enacted their own AI accountability laws, leading to a patchwork of requirements. Due process is primarily enforced through judicial review and constitutional protections, but there is no statutory right to explanation or contestation for automated decisions. This fragmented approach creates compliance challenges and legal uncertainty for both government and private actors. The global landscape for regulating algorithmic decision-making is rapidly evolving. While some jurisdictions lead with comprehensive, rights-based frameworks, others are still building the legal and ethical foundations needed to protect individuals in the digital age. Ongoing reforms and international dialogue will be key to achieving greater harmonization and safeguarding public trust in automated systems.